Yeah, they're here. I'd like to welcome representatives from Multicultural Australia, Rose Dash, Chief Client Officer, Erica Jung, Program Manager, Humanitarian Settlement Program, and Emma Phillips, Research and Advocacy Manager. Welcome, everybody. Invite someone to make a statement of about 5 minutes duration. We've been asking people to refrain from using unparliamentary language, such as swearing or offensive terms. I know you wouldn't do that per se, but in quoting someone else, sometimes that is unparliamentary. So we ask you not to quote someone if they are using unparliamentary language. The other thing we ask the witnesses to consider is naming other persons who may not wish to be identified in a public space. I don't know if you're intending to do that, but if you are, if you could just respect that, please. And yep, over to you. You've got 5 minutes or so to address the committee, after which the committee will have some questions for you.
Great, thank you. I'd like to begin by acknowledging the traditional owners of the land, which always was and always will be Aboriginal and Torres Strait Islander land. We pay our respects to their elders throughout all time. We walk together in solidarity of the shared pain of the past and the shared hope for the future. Thank you for the opportunity to provide a submission to this important inquiry and for the invitation to give evidence at this public hearing. My name is Rose Dash and I'm the Chief Client Officer at Multicultural Australia. I'm here today with my colleagues Erica Jung, Program Manager of our Humanitarian Settlement Program, and Emma Phillips, our Research and Advocacy Manager, who manages the team who authored the Multicultural Australia submission. I make this opening statement on the behalf of myself and colleagues. As Queensland's settlement service provider for migrants and refugees, Multicultural Australia works closely with diverse multicultural communities in Queensland, from new and emerging communities to more established communities. With our major offices in Brisbane, Toowoomba, Rockhampton and Townsville, and community hubs located at multiple locations across the state. We provide support services across Queensland for between 5,000 to 6,000 clients each year through a range of programs, including refugee humanitarian support, employment and youth programs. As the committee will appreciate, our experience providing settlement services has given us direct insight into the ways in which Queensland's life registration system does not appropriately accommodate the specific experiences and requirements of humanitarian new arrivals and refugees. Our submission draws on our experience supporting new humanitarian and refugee communities who have been impacted by the residency requirement in relation to the registration of adult and child name changes, and trans and gender diverse refugees who've experienced barriers from the restrictions pertaining to applications to change their sex on their birth registration. Our submission also notes the current prescriptive requirements under the BDM Act that can exclude or impose hardships on vulnerable community members, including refugees and humanitarian arrivals. Our submission is primarily focused on highlighting these issues and proposing reforms which we would consider appropriately would address these issues. The second part of our submission offers our perspective on issues arising from the operation of the BDM that impact the broader community. Multicultural Australia has recently been awarded Rainbow Tick accreditation after successfully meeting 26 criteria across 6 standards in order to work towards a more welcoming and inclusive space for LGBTQIA+ people. This is a significant milestone for our organisation and reflects our strong commitment to supporting our clients and communities, as well as our workforce, to feel safe and respected in their identities. As stated in our submission, reclaiming identity can be a key settlement priority for new arrivals, many of whom have experienced torture, trauma and persecution as a result of their identity in their country of origin. Obtaining identity documents that correctly reflect their identity is a critical part of the settlement journey and trauma recovery. As outlined in our submission, we are broadly supportive of the bill. In particular, we support the strengthening of legal recognition of trans and gender diverse people beyond the medicalised model to reflect their lived identity. The recognition of diverse family and parenting arrangements, the introduction of recognised detailed certificates and procedural changes that will simplify and align the registration requirements, which are currently onerous, particularly for people who speak English as an additional language. We offer the key recommendations for the committee's consideration. Amending Clause 8(2)(b) of the bill to expressly recognise in the text of section as an example the situation where a child is born in Queensland and one birth parent is overseas and unable to sign the application to register the birth within the required timeframe, which is quite a significant impact for some of our families that arrive. In relation to name changes for both adults and children and sex changes for adults, removing or reducing to 3 months the residency requirement, including an exemption for humanitarian entrants, and procedural and access to justice recommendations, including further reducing and simplifying the information requirements for registration, introducing a discretion for the registrar in circumstances where inclusion or removal of certain information on a certificate may cause significant distress, increasing the flexibility of the notification and application process, and formally implementing fee waivers for disadvantaged groups, including refugees and other humanitarian entrants and First Nations persons. We wish to emphasise the importance of ensuring there is adequate community education about all changes to the registration framework, especially those that have particular relevance for culturally and linguistically diverse communities. We have a case study that my colleague, Ms Young, can speak to that helps to highlight the ways in which the current requirements can experience as barriers for our clients and communities. With the committee's consent, I will now hand over to her to present these case studies.
Thank you.
Yeah, thank you. Thanks for the opportunity to present a case study. So Multicultural Australia has supported a highly vulnerable client who arrived as a refugee from Iran. Prior to her arrival in Australia, our client, who is transgender, experienced significant ongoing physical, psychological, and sexual abuse from her family and from others in her community. The client lives with significant trauma from this experience and is still awaiting surgery in relation to some of the injuries she sustained as a part of this abuse. Our client was ultimately rejected from her community due to her transgender identity and initially thought refugee in Turkey before arriving in Australia as a refugee. Our client arrived in Australia with the male name she was given at birth recorded as her legal name, and notwithstanding that she did not identify by that name, did not identify as male, and presented in all respect of female, having accessed to hormone therapy treatment over a number of years. Due to the cost and her physical emotional injuries, our client has not yet accessed surgical intervention to reflect her change of gender. Our client sought and was assisted by a community legal center to apply to change her name to her female name, and this process was ultimately successful. However, our client was unable to correct the record of her gender in the registry or to have her self-identified gender noted on her name change certificate. Our client experienced significant trauma as a result of her identity to obtain any official document reflecting her gender. For this reason, the proposed amendment permitting name and sex changes to be made simultaneously, and without gender reassignment surgery would be very beneficial. As a related point, we note that our client has experienced barriers when seeking to change her name on her IMI card, which point to the need for review and alignment of related systems. Thank you.
Thank you. You're open for questions?
Yeah, thank you for the opportunity.
Laura?
Thanks, Chair. Thank you. Thanks very much. So one of your recommendations in your written submission is that there be further engagement, consideration and consultation in relation to the terminology of sex and gender in the bill and related legislative instruments. I'm just after an expansion on that, please. What would you like? Further consideration, consultation and engagement in relation to that?
Thank you very much for the question. We're probably not the experts to speak in any depth to this. We have noted, and I can give as an example, the use of the terminology in the bill, the definition of sex descriptor as either male, female or any other descriptor of sex, and then the examples given are more associated with gender. I have had the opportunity to read the submission by the Queensland Law Society, which goes into that in further depth, as well as other submissions. We're simply noting that, and we do recognise there may be some implications for other pieces of legislation as well, so we wanted to draw that to the committee's attention.
Thank you. John? Sandy?
Thank you, Chair, and good morning. The example given by a client just previously, would that situation and the trauma and the stress that she has undergone, would that have been alleviated by the option, as has been brought forward earlier, of a gender identification certificate instead of amending the actual birth certificate?
I think without being able to ask the client the question itself, I think that's, us making an assumption on that. But I think I would say that for a lot of our clients experiencing, the barriers to the current system through this, everyone will have their own perspective on what would satisfy that. I think at the moment, though, what we're finding is, because of first the 12-month period in which they have to live in Queensland to change their name, as well as sex, is quite a significant barrier, and I guess perpetuates that trauma that they've experienced offshore as well. Whereas us as an organisation can refer to them as where they self-identify their name and their sex, other agencies don't, and that's a constant reminder. I think in any system, whatever will be capable of being able to allow that person to live to the identity that they self-identify as, and ensure that systems that they're interacting with and accessing are able to accurately reflect that on an ongoing way. And I guess when you're settling in a new community, you are setting up everything from scratch. So you are doing your bank account, your Centrelink, your school registration, any ID documents, but even just filling out many different forms. And so it just perpetuates the trauma at this point. So I'm not sure if I answered that question well, but I don't know if, Erica, you wanted to add to that?
I think, for many of our clients and community members, and, even the gender identification certificate is a really foreign or unfamiliar system to go through as well.
Mm. And if I could just add further to that, and I do understand this has been a focus of interest this morning, I think what is paramount is the safety of the client in terms of the documentations that they have in their possession and are required to show in an external facing way. We absolutely appreciate the importance of accurate historical records, and I know submissions, for example, Jigsaw, Queensland and Family Voice Australia have spoken to the need for there to be a historical record, and we absolutely appreciate that. But in terms of the safety of transgender people, I think it's really important that they are not required to have two separate certificates that might possess or reflect different information about their gender. So we would propose that there are other ways in the back end of the registry that can be achieved, where an accurate historical record can be maintained with really appropriate appropriate safety settings in terms of the privacy and confidentiality of that information, while having any documentation published reflecting their lived experience of gender.
Wonderful. Thank you.
Jonty?
Thank you, Chair. Thank you for your submission and for attending today. You proposed amendments to clause H2B, and I just wanted to see if you could expand on that a little bit while we've got you.
Do you want me to speak to that? Yeah, so what we've proposed in our submission is amending clause 8.2b to expressly recognise the situation where a child's born in Queensland and only the birth parents in Queensland, and the other parent's not practically able to sign the application within the required time frame. And we did note that there's a number of humanitarian entrants in that category. In clause 8 subsection 3. There is the exemption created, but on our reading of that, that will only be activated once the discretion is exercised under clause 8 subsection 2. There are, and we've noted in our written submission, so there are obviously examples provided, but they don't really align with the circumstances of our clients, and we are concerned that in practice the administrative decision making on this section it would be significantly improved if either there was a rewording of that section or an example provided to reflect that situation that many of our clients have found themselves in.
Okay.
Yeah, an example of that would be, for example, a client many years ago gave birth to a child where the father was overseas and missing. And so on the application, it's asking for the father's name, but no examples or explanation to what would be the exemption criteria and would that fit under that. And so there is already significant trauma and settlement stress happening just purely to settle here in Australia, and you've just given birth. And then to try to figure out if there is a way to register the birth of your child without any clear examples of if that could be exempted. So what happens is the clients then come to services or seek legal advice to understand if there is a way around that. So while we're not assuming an exhaustive list of different examples, ways of being able to, in simplified English, being able to explain there's ways of getting that exemption would be really helpful for the cohorts that we support.
Okay.
Thank you. Jason? You got a question, Jason?
You're on mute.
Jason, your boomer, you're on mute.
No, he came off mute, but we still can't hear you. All right. Jonty?
Yeah, thank you. You've also made some comments in relation to the proposed requirement to be a resident for 12 months. Sorry, my computer. Prior to making an application to change the name. Again, if you could just expand on your views on that and why you've included that in the submission.
Yeah, thank you. I think in the current Act, there is no specified length of time. There is a minimum requirement. In practice, though, it has been a requirement for anyone born overseas to have lived and prove that they lived in Queensland for 12 months before changing their name. For a lot of our clients, they arrive and there's possibly an error on the documents that they've been given, or the naming conventions that are quite common in their country of birth and country of origin don't reflect or enable them to integrate here, and they would like to choose to change their name. So there's varying different circumstances. However, what happens because of this 12-month criteria is they're having to wait and kind of set up all the systems of settlement, as I explained before, those different systems in that incorrect name, and then to change that name 12 months on. The other challenge to that is that the intensive settlement support that they receive through the humanitarian settlement program happens within that initial 12-month period. So at that 12 months, they are about to graduate that program and go into a less intensive stream. And so if there are any barriers to that, then they are having to come back to do that. So And it's not just to change the name, it's then to change your name with all the other systems that you've just set that up. So for us, what we'd recommend is either abolishing that and just enabling that exemption for humanitarian entrants to do that on arrival and be able to provide the reasons behind that, or at least give a 3-month window if you need to provide some kind of minimum requirement so to enable them to be able to set up their life here in Australia. Yeah.
Jason, we'll try again. We couldn't hear you before. Obviously, you can hear us. You want to have another crack at it, or do you want me to ask the question? No, we still can't hear you, mate. All right. Jason has this question. Your submission talks about the term birth being outdated. Would you be kind enough to expand on that part of your submission, please?
Sorry, I'm just looking for whereabouts in our submission we've made that reference. I do, I just have to pull up the definition. I
think it's, sorry if I might help, on page 7. I've just done a word search for you.
Thank you.
Under recognition of contemporary family and parenting structures.
Thanks, Laura.
Yes. Yeah, and I'm just going to the definition at the moment. But I believe in the Act, birth is defined along the lines of expulsion from a mother's body. Is that correct? Sorry, I'm not able to speak to that in too much detail at the moment, but my reading of that section is that it certainly was not reflective of current understandings of the different ways that a child can be brought into the world. So it was on that basis that that point was made.
Thank you. Unless anyone, this will be the last question.
Thanks, Chair. Thank you. I just wanted to touch on that aspect of the bill that Multicultural Australia didn't agree with, or that you said that you don't support. So you said to delineate between prisoners and restricted persons and other persons in the rights and conditions attached to the application to the register a change of sex. I just wanted you to expand on why you don't support that amendment and any further details you can give to the committee around your recommendation there. So it's on page 9 of your submission, and it's numbered 1, and it's under the heading Multicultural Australia does not support the following proposed amendments.
That's where we support. This is the yes, and again, this was not a point of core focus for our submission, but just something that we are concerned about that would impact potentially some of our clients and communities, and more broadly as a human rights concern. We wanted to flag that for the committee's attention. I think there's other organisations, for example, Sisters Inside and the Queensland Law Society, that can speak to this and have greater experience in this space directly. But we were concerned that on our reading of that provision that it is discriminatory, and that there wasn't, that doesn't appear on our reading of that to be any reasonable basis upon which to make that delineation.
Thank you. That brings to conclusion this part of the hearing. We thank you for your submission and thank you for your attendance. We now... All right, the next witness is Professor Peter Copeman. He'll be on video conference. Oh, sorry, Professor. Come forward when you're ready. Thanks, guys.